Good afternoon, this is Sean Golden with Golden & Golden, here to discuss a common question that we get for taxpayers who are not considered non-willful and have to enter the Voluntary Disclosure Program, and that's whether you will receive protection from criminal prosecution if you enter the Voluntary Disclosure Program, and the typical answer is yes. The idea is by submitting to the program, you are voluntarily coming forward, you make a full disclosure, and then you avoid prosecution. It's not guaranteed, but to date, we've never had anyone criminally prosecuted if they enter the program. Let's go through some of the basics. So the Voluntary Disclosure Program, or IRS Voluntary Disclosure Practice, has been around forever. At our firm here, we specialize exclusively in offshore matters, investments, assets, accounts, and income. The program is used to disclose unreported money depending on what the issue is. Like I said, we do offshore, there's employment, trusts, all that kind of stuff. But the idea behind it is if a person is willful or they can't certify under penalty of perjury that they're non-willful, then they don't qualify for one of those other kind of warm and fuzzy programs like the streamlined procedures, delinquency procedures, and reasonable cause. A couple important things to keep in mind is voluntary disclosure is still a civil mechanism. You're not going in and making a plea agreement. You're not going to prison or avoiding jail directly just by submitting to the program. It's civil in nature. And the idea is by doing it, you're acknowledging that you were willful and that you want to avoid potentially worse penalties and potential criminal investigation or prosecution. But you are not per se making a criminal acknowledgement, okay? It's important because there's willfulness civil and willfulness criminal. In order for someone to prove civil willfulness, for example, civil F-bar, let's say, it's still preponderance of the evidence, which is the lowest standard. If you go into criminal court, it's beyond reasonable doubt, okay? So first thing to keep in mind, by entering the program, you're not making a criminal acknowledgement per se, you're just acknowledging that you're willful, okay? When it comes to willfulness in the civil arena, it's not just intent, right? That would be common sense, and why use common sense, right? There's things like reckless disregard and willful blindness, which are lower levels, one, no necessary intent, one without any knowledge, but it doesn't qualify as non-willful or reasonable, again, but it doesn't necessarily mean you acted intentionally. By entering to the program, you're making what's called a full disclosure. I get this all the time. I've got some accounts in the country, my great-grandma has been banking there forever, and there's no way on this planet that bank would ever give my information to the IRS. Well, you have to go in with the idea that you have to make a full disclosure. You never know what the IRS may know. You could be stuck in a reverse eggshell audit, sensitive audit, in which, maybe that bank had an agreement with another country and your information just kind of got in there. IRS finds out later that you didn't make a full disclosure. That's bad. And that could lead to special agent investigation, criminal prosecution. So you don't want to go that route. You want to go in with the idea that you're making a full disclosure. And as part of the program, you do the pre-clearance letter, which is the 14457. And then you also, there's a part 2 to it that you do later in the process. And you're essentially acknowledging there's 3 subsections you have to complete. Again, you're acknowledging that you're willful. But a great benefit to the program is that you will get a closing letter in 906, which basically means that the program is over and that you've completed it, assuming that you made a truthful and full voluntary disclosure. And that is essentially the end of the matter. For the most part, it should avoid any criminal prosecution and it should avoid any immigration issues. I know there's some fear-mongering online, making people sound like if you enter the program, they're going to deport you or remove you. We've yet to have that happen. I guess it could happen. But I haven't seen it because it doesn't seem like that goes with the spirit of the program, which is to voluntarily come in compliance. Immigration is handled through USCIS. Taxes are handled through the IRS, and they don't rarely meet unless it's a really serious issue. A few things about the program to also keep in mind is it was revised in 2018, 2019, and typically it's going to be a 50% penalty, but it can be negotiable. The agents generally don't negotiate it because they have to get approval, and most of the higher ups, the idea is that they're allowing you to avoid criminal prosecution. That's sort of the carrot and the stick, and so they're not just going to also reduce the penalty, but it happens sometimes. We've done it on a few occasions here. So we know it can be done. If you're out of compliance and you want to get into compliance, you should speak with some board certified specialists who really focus on offshore. Get a lay of the land. Don't assume you're willful because you read some garbage online, and don't assume you're non-willful just because you don't want to be willful, right? You got to really go through the facts. It's no bright line test. It's more of a totality of the circumstance. If you're non-willful, there's various other options available to you. There's the streamlined procedures, delinquency procedures, and reasonable cause. We have a ton of free information on our main websites and our sub-websites. You can always reach out and schedule a reduced fee initial consultation if you think it's appropriate. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.